Hello friends, welcome to the Canadian Law String. In this session of our video, we will be discussing about the nature and the sources of the Constitution of Canada. I want to put a small thing before you people that if you refer to the videos which I make, I think this would be enough for you to qualify the NCA exams. You do not need to be dependent on any other sources. So watching my videos would, I believe, be enough for you people to qualify the exam of NCA. So let's start with the Constitution of Canada. The Constitution of Canada is not a codified document like the Constitution of India or the Constitution of the United States of America. Since Canada was a country which was ruled by UK, the Queen was ruling over it, so they followed the UK system. And the UK system is the Constitution of UK is not codified. So the Constitution of Canada comprises of 9 things. It's not a codified constitution. It comprises of 9 things. So the first is Constitution Act of 1867. The second is Constitution Act of 1982. The third is Constitution of Canada under 1982 sections. The fourth is Imperial Statutes. The fifth is Canadian Statutes. The sixth is Parliamentary Privileges. 7th, case laws. 8th, Prerogative, and 9th, conventions. So the Constitution of Canada comes from these 9 sources. So the source is not one. It is combined from 9 sources together to become a constitution. So let's start with the first source, which is called as the British North America Act of 1867. So the British North America Act of 1867 was enacted with a goal of creating a confederation. Confederation means they wanted to create a split from the United Kingdom such that the administrative setup of British North America could be run in an efficient manner. So the entire British North American territory was a colony of UK, United Kingdom. But it was having problems because the administrative setup and governance setup were having some problems. So the UK Parliament decided that a split should be created and the British North American territories should be allowed to function on their own self such that they could function efficiently. So the goal was this, to create a split such that the British North American territories could be function independently from UK. So there were 3 colonies of British North America which first united to become Canada. Those 3 colonies were Nova Scotia, New Brunswick, and the colony of Canada. These 3 colonies together came to be known as Canada, the province of Canada. So a province was created, and that province comprised of 3 territories. Now, these provinces were to have a federal setup. These provinces were established by the rules of federalism. That means the powers were allocated. The governmental powers were allocated at the central level and at the provincial level. Central level had their own federal system of enacting laws. Provinces had their own system of enacting laws, and subjects on which the federal government would enact law and subjects on which the provincial government would enact law were separated. Provincial legislature was different from federal legislature. But as you know that they did not follow the model of the Constitution of United States in codifying the new nation's laws, and it was mentioned very clearly in the preamble of British North America Act that they would be having a constitutional setup which would be similar in principle to that of the United Kingdom. So some of the most important rules of Canada were not matters of law at all, but they were simply conventions, and those conventions that were unenforceable in courts of law. since you people know that the Constitution of United Kingdom is heavily dependent on conventions. They regard a great value to conventions. The same was the case with the British North American Act, which gave more importance to conventions, and many of the conventions were unenforceable in the courts of law. So there was another thing. There was also the absence of an amending clause within the British North America Act. If any of the provisions of the British North America Act were to be amended with changing circumstances, there was no provision of amending the said clause within the Act. If an amendment was to be brought, then it had to be brought by separate law. So till 1982, from 1867 till 1982, a series of Imperial Statutes were brought in order to bring amendments to the British North America Act of 1867 from time to time. Now, let's do the criticism of the British North America Act. See, the first thing is, the office of the Governor General was never formalized in the British North America Act, nor in the amendment of the British North America Act. Since you people know that the Governor General was to work under the authority of the Queen. He was the representative of the Queen in Canada, in British North America, and he acted on the advice of the Queen. He was appointed by the Queen, but how would he be appointed? The rules and laws pertaining to his appointment was never dealt under the British North America Act. He was appointed by convention. You see, convention is playing a very important role. He was simply appointed through a royal prerogative made by the Queen. Although Queen was to act on the advice of the cabinet ministers, her Canadian ministers, but he was appointed by normal prerogative, which the entire setup you could call is as a convention. Second gap: the rules for the responsible system of government was never written in the British North America Act. How would the British North America Act, British North America, American territory, how would it be ruled? Was nowhere mentioned. What system of government would be adopted to rule and administer British North America Act, American territory, was never mentioned in the act itself. So for this, again, it was dependent on convention. So it was run by a responsible government, a government of cabinet headed by the Prime Minister. So the majority, like the House of Commons. So the legislative authority in terms of the form of government was also left to an unwritten convention, as in the UK. Third thing, as you people know, I have already mentioned that there was no amending clause within the Act. If any amendment had to be brought in, it had to be brought in through a separate Imperial Statute. Fourth thing is, there was no mention of the rules pertaining to the functioning of Supreme Court. How would the Supreme Court function? Nowhere it was mentioned. Though it was said that the rules for Supreme Court would be brought, but it was nowhere brought in this act. And the most important of all things is civil rights, the freedom of religion, equality, freedom to practice religion was nowhere mentioned under the British North American Act. So the civil rights were not protected. They were left to the UK common law. And with this comes the end of the first source of Canadian constitutional law, the British North America, which is called as the British North America Act of 1867. Thank you, my friends.